Good afternoon and welcome to today's webinar, Looking to the Future, Flexibility in Public Protection. I am Richard Williams, I'm a Policy Associate at the SRA and I've been working on this particular project. I'm joined today by Maxine Warr, who is a Policy Manager and also been working on this particular project. Just in terms of housekeeping before we start, you'll be able to see a button at your top right hand part of the screen. If you have any technical difficulties, please contact and press that particular button and someone will assist you. Please, and we encourage you to do so, feel free to ask questions throughout this webinar. You should see a question box. We will try and answer all of the questions at the end of the webinar, but if we don't, we'll take them away with us and we will put those on our website. So I'm going to hand over to Maxine now, who's going to kick off the webinar.
Thank you, Richard. Hello, everybody. So in this webinar today, we are going to talk to you about our plans for a phased review of our regulatory approach. And this review will also include a review of our regulations and the Code of Conduct in the SRA Handbook. To launch the review, we have published today on our website a paper which is entitled Looking to the Future, Flexibility and Public Protection, a phased review of our regulatory approach. And in that paper, we set out at a high level the next steps in our ongoing programme of regulatory reform. So the programme of reform is designed to make sure that our regulation reflects the realities of a rapidly changing legal market and that our regulation delivers our core regulatory purpose. And just as a reminder, our core regulatory purpose, as we said in our May 2014 policy statement, which incidentally we also updated and we published today, is to provide appropriate protection for consumers, to support the operation of the rule of law and the proper administration of justice. As I said, the Looking to the Future position paper is now available on our website, and it sets out at a high level the details of the way we're planning to review our approach. It sets out the reasons for the review. It sets out some of the issues that we've got with our current arrangements. And it also sets out our early thinking about how we might develop our approach to regulation and our regulatory arrangements. And this early thinking has already been informed by some early discussions with stakeholders, and this is the next stage of that process. Moving on now to slide 2. So the purpose of the webinar today is to let you know about the publication of the position statement. It's to share with you our early thinking on how we propose to reform our approach to regulation and what we do. It's to set out what that might mean for the SRA Handbook, and it's to share our early thinking with you on what our regulation might look like in the future. A really important point that we want to make today is that this is an ongoing process. So as I said, we've already had some early conversations with some stakeholders, but we want to continue to talk to the widest possible audience in advance of a formal consultation which will take place in spring 2016. And this session today forms part of those wider discussions, and we would really welcome your feedback and your views. As Richard's already said, at the end of the session there will be a chance for you to let us know what you think. We really want to hear what you think. And there will be an opportunity for you to ask us some questions, some of which we'll be able to answer today, but some of which we will publish answers to on our website. But please do be assured that any questions you do ask us will be recorded, we will be looking at them, and we will make sure that we feed them into our future work. Also, throughout the webinar, we'll be asking you a number of quick questions relating to the content of the webinar, and again, a summary of those will be made available on our website. So moving now on to our first question, slide 3.
So our first question is really to get a sense of who's listening and taking part in today's webinar. So very simple, who are you? And you should have on your screen a number of possible answers: solicitor, partner, in-house solicitor, co-op, coffer, sole practitioner, REL, or none of the above. If you could just take 20 seconds to pick the one that is most applicable to you, that would be very helpful. Thank you.
Thank you for that, and we'll make those answers available on our website. Moving on now to slide 4. I just want to give you a bit of background to our reform programme, after which Richard will then talk you through some of our early thinking that we've set out today in the position paper. So let's just go back to May 2014. I said already that in May 2014 we published a policy statement which was called Approach to Regulation and its Reform. And in that paper we explained that the purpose of our regulation and we explained how we set out our regulatory requirements to achieve that purpose. We said in that paper that we believe that if we're clear about what we do and why we do it, it would help solicitors and firms and all of those people affected by our regulation to understand our reforms. And we also hoped that it would help you to have greater confidence in our work and in our future direction. As I've already said, we've now updated that policy statement to take into account changes that have been made since it was first published in 2014. And this has also been republished on our website today, in addition to the Looking to the Future position paper, which is the subject of this webinar. A really important point to make at the outset is that the purpose of our regulation has not changed and will not change. Our primary role will continue to be the regulation of solicitors and firms and organisations to ensure that they properly fulfil their obligations to the court, to the proper administration of justice, and to protect consumers. Having said that, we're also very clear that our regulation must continue to evolve if it's to remain appropriate and relevant to the market and the wider environment within which we operate. In our corporate strategy, we've got 4 key aims, and the first of these key aims is to reform our regulation to enable growth and innovation in the market and to strike the right balance between reducing regulatory burdens and ensuring consumer protection. And this current review is part of an ongoing programme of reform that's designed to meet that aim. So in summary, the objective of our current review is that we hope that all solicitors will be bound by clear ethical standards, that they'll deliver a proper standard of service and meet the competences set out in the SRA's competence statement. Also, that consumers receiving legal services from solicitors and regulated firms will receive the appropriate protections and that they'll understand what they are. And in addition, it's also important that regulation presents no unnecessary barriers or restrictions and that it will enable growth and innovation in the market, benefiting both the profession and consumers of legal services. So why do we think we need to change? Let's move on to slide 5. One thing that's very clear, it's very clear to everybody, is that the legal services market, the way that people choose and people buy legal services, is changing faster than it ever has done before. These days we're seeing people buying services from such a wide range of different legal services providers. This can range from individual members of the public buying a will or managing a divorce, small businesses seeking legal advice to help their business grow, or even global corporations looking to align their legal service suppliers into a sophisticated supply chain. We're also seeing changes in the way in which legal services are delivered. So, for example, we're increasingly seeing legal services provided online. We're seeing more legal process outsourcing. And we're seeing much more unbundled legal services, where the legal services provider undertakes part of the work and the consumer does the rest themselves. What we also know is happening is that people are using services outside of legal services regulation. And to reflect that, there's also a much stronger consumer protection and competition law than was ever envisaged when our current regulatory model emerged in the 1970s. So we know that solicitors obviously continue to work in traditional firms, but also increasingly we know that they are working within businesses other than traditional solicitor firms. So, for example, many solicitors now operate in regulated firms that combine different types of regulated lawyers. And of course that applies to other regulated lawyers too. Around 15% of barristers, for example, work in organisations regulated by the SRA, as do many notaries, legal executives and conveyancers. And this means that we're no longer regulating just solicitors, but we're increasingly becoming a regulator of the wider legal services market. In addition to this, many of the owners and managers of the firms that we regulate, they're not solicitors or lawyers of any sort, and multidisciplinary practices can be made up of lawyers and other business professionals such as accountants. What all of this tells us is that the legal market is responding, and it's responding both to public and business demand with new forms of practice and new forms of service. However, what we also know is that a large number of individual members of the public are still not accessing legal services when they face problems. And many small businesses see legal services as essential, but they just can't afford them. And this is a problem that we think we need to do something about. What we need to do is we need to reform our regulation to encourage even more innovation and even more growth to benefit those consumers who are still not able to access the services that they need and the services that they want. So if we turn now to our regulatory framework on slide 6, many of you will be aware that in recent years we've already made significant changes to our regulatory arrangements. And the aim of these changes has been to provide greater flexibility for solicitors and greater flexibility for solicitors' firms, and to allow them to maximise their competitiveness. For example, we recently introduced reforms to the separate business rule. These reforms allow solicitors to own and manage legal services firms that we do not authorise and that we do not regulate. We've also removed obstacles to multidisciplinary practices where firms deliver legal services and other services such as accountancy in a one-stop shop. But we don't think that these reforms have gone far enough. We think we need to build on them, and we need to continue to find ways to encourage innovation and growth. As many of you will know, our current handbook was first published in 2011. When it was published, it represented a significant progress towards modern regulation. It saw us transitioning from being a traditional rules-based regulator to an outcomes-based regulator with a focus on managing risk. But having said this, we still think that our current handbook reflects to a great extent the position before the introduction of the Legal Services Act, when we overwhelmingly at that time regulated traditional law firms and solicitors practicing in those firms or in-house solicitors. So, for example, our rules still say that solicitors in firms not authorised by us or another legal services regulator can't at the moment deliver any legal services to the public except in certain limited circumstances. And we're concerned that these type of restrictions go further than those that are required by legislation, and we're concerned that they're no longer fit for purpose. For example, they may prevent membership organisations, charities, local authorities from providing legal advice to the public at an affordable price. We're also concerned that our current prescriptive rules put narrow and restrictive constraints around solicitors and authorised firms. So what we want to do is we want to focus on the key standards for individuals and the organisations that we regulate. We must make sure that they're protecting consumers and upholding the rule of law. But at the same time, we want to provide the necessary freedom for individuals and entities to compete freely in the market. And this will be at the heart of our reforms. What we want to make clear, as I've already said, is that the fundamental foundation on which our regulatory approach rests hasn't changed, as we said in our policy statement. So any changes that we do make to our regulatory model will align to our core regulatory purpose. We'll take into account all of the regulatory objectives set out in the Legal Services Act, and we'll also be mindful of best regulatory practice. And in particular, we want to make sure that our regulation is proportionate and that it's targeted only where it's needed. Richard's going to explain shortly our early thinking, but the starting point for our work and for our reforms will be to explore how best to regulate individual solicitors on the basis of the services that they provide, on the basis of who they provide them to, rather than on the type of organisation that they work in. And this will help us to identify the best regulatory approach to provide the necessary level of protection for public and consumers. We're very clear that to enable firms to make their own business decisions, to innovate and to grow, we need to move towards a more flexible and less prescriptive regulatory model. So, under our proposed approach, we would only create rules which prohibit or restrict an activity where we consider that there's such a serious risk of harm to consumers or the rule of law or the proper administration of justice that such measures are needed. So hopefully that's given you a little bit of background, a little bit of context to our reforms, and hopefully explains to you why we've launched this reform programme today. I'm going to hand over now to Richard, who's going to give you a little bit more detail about the actual proposals that are set out in our position paper. Moving on to slide 7.
Just before we do that, we have a second question for you. Much of the work that we're proposing today will obviously be around the content of the handbook. In addition, we also want to think about how individuals that we regulate use the handbook. So we're quite keen to know how you use it and which part of the handbook you use most. So we're going to ask you a question. On average, what part of the handbook do you use most? And you have a number of answers there. So if you could spend 10 seconds picking the one that you think you use most, that would really help us shape our thinking. Okay, moving on to slide 8. Maxine has outlined the reasons why we think we need to review the way we regulate. In terms of what we want to achieve from this process, we want to achieve and obtain a handbook that can cope with the variety of modern practice, embrace new ideas for delivering legal services, and ensure that the emerging dynamic legal market works for both consumers and the public. Maxine's talked about the changing legal services market, and we want to give solicitors and firms more flexibility to focus on their business and customers and make it easy for you to provide flexible legal services. To do this, we'll have to address any unnecessary restrictions as part of our current handbook and the way we regulate. These restrictions typically prevent solicitors, except in very limited circumstances, from practicing businesses that are not authorised by the SRA or other legal services regulators. Some of you will be aware of the recent Legal Services Board consultation on whether frontline regulators and their rules exceed the requirements of Section 15 of the Legal Services Act. We agreed with the OSB. Much of our rules, particularly in the practice framework rules, do exceed what is required from a legislative perspective. Through our work, we also want to be clear on the public protections and help people that use legal services understand how they are covered. It's important we find the right balance in our regulation between flexibility and these consumer protections. A large number of individual consumers still don't access legal services when they face the problems. And small businesses in particular are seeing services as both essential but also unaffordable. There's a real challenge in there for us. We need to be able to facilitate and enable increased access to affordable, competent and ethical legal services. The more we can do this, the greater opportunity all consumers of legal services will have in terms of access to meeting their particular needs. Moving on to slide 9. We've developed a model of regulation that we think can deliver these objectives. It's important to note at this stage this is simply a model for discussion and no decision has been made. We have lots of thinking to do, and we need your views and your thoughts to help us shape and determine our thinking. As Maxine's pointed out, the proposed new approach would retain the framework of and build on our existing legislative foundations, including protection of the solicitor title and reserved activities. So what would this model look like? What are our proposals? So the starting point for us is to explore how best to regulate individual solicitors on the basis of the services they provide and to whom, rather than the type of organisation they work in. Under our thinking, all solicitors, regulated entities and their managers and employees will be subject to a set of professional principles and a code of conduct. Our starting point is really to think about the 5 professional principles that are set out in Section 1 of the Legal Services Act. And they are that authorised persons should act with independence and integrity, authorised persons should maintain proper standards of work, authorised persons should act in the best interests of their clients, persons who exercise before any court a right of audience or conduct litigation in relation to proceedings in any court, by virtue of being authorised persons, should comply with their duty to the court, and that the affairs of clients should be kept confidential. That's our starting point. We want to have a discussion and a debate whether we need more principles or whether they cover, in essence, the core obligations of a solicitor. Individual solicitors under our new model, wherever they are based, will also be subject to core personal regulatory requirements, wherever they practice. These will comprise qualification and ongoing competence requirements adhering to the professional principles I've just mentioned and to the individual code of conduct. Our starting point is to look at the current code of conduct. We think that as it currently stands, it's subject to duplication and repetition. Some of the outcomes could be much clearer. Some of the outcomes are unnecessarily detailed, and that there are significant areas where it's likely that the code of conduct can be sharpened, shortened, future-proofed and better focused. We want to assure that any code going forward is proportionate and targeted and delivers competent and ethical solicitors. Under our thinking and our model that we're proposing, we will review our practice framework rules. And we'll do this to enable and remove current restrictions that prevent solicitors providing non-reserved legal services across the whole legal services market. Our thinking is based on the fact that solicitors will be free to practice in the wider legal services, delivering non-reserved legal services to the public outside of firms that we regulate. And obviously that is a step forward in terms of the current position, whereby our practice framework rules currently restrict, unless in limited circumstances, that happening. Individual solicitors may deliver other non-reserved legal services to the public or a section of the public by practicing in an unauthorised entity, but if they do, under our thinking, regulatory protections such as access to the legal services ombudsman and complaints handling obligations in the code of conduct will be relevant. Depending on the nature and the circumstances of their practice, we may also apply the following: that individuals cannot hold client money under SRA authority, they have no or restricted access to the SRA compensation fund, and that solicitors are subject to the complaint handling and ombudsman obligations that I mentioned a minute ago. We don't consider that these changes represent in any way a watering down of the solicitor's brand. Actually, we think the opposite. We think the changes should strengthen the solicitor's brand. With increased visibility and availability of solicitors who are competent and ethical, consumers have a far greater range of opportunities and ways in which they can access a qualified professional when they want or need it. As part of our thinking, we really want to make the obligations on individuals and entities much clearer. As Maxine mentioned, one of the biggest disadvantages of the current handbook and the way that it is constructed and articulated is that it does mix up both individual and entity obligations. We need to change that. So under our model, we'll have individual-based regulation, and this will be based on competence, ethics, values and behaviours, and will be delivered through a code of conduct together with competence requirements. In addition, there will be a separate, short set of rules that apply to the entity, and these will be focused on making sure that a business has the appropriate level of protections, systems and controls in place. Our model takes primary legislation as its starting point, and we think in terms of moving forward, regulation and entity regulation will apply to two groups. There will be those that will be delivering reserve legal services to the public and therefore must be regulated, and those who do not deliver reserve legal services to the public at a given point in time but want to be entitled to do so. Key to the success of our approach will be ensuring and making it clear to all stakeholders that there are a minimum set of standards and safeguards. There will be one risk-based framework for all regulated entities. This framework will be sensible, proportionate, and will be absolutely clear on what the requirements on those entities are and how they will have to apply for them. And importantly, the framework will be broad enough and flexible enough to cover the range of entities and business models that emerge in this rapidly evolving legal services market. So we have another question to ask you. This is slide 10 and question 3. The question really is around what I've just talked about in terms of the separation of rules between individual and entity. And we want to know whether you think that's helpful. So you should have a yes, no, or a I don't know selection on your screen now. So if you can take five seconds to pick the one that you think applies to you, that would be very helpful. Okay, thank you. Moving on to slide 11. I want to talk in a little bit more detail now about the benefits that this review might well bring. So, we think our model, our current thinking, provides a more flexible, less prescriptive and more accessible regulatory model. We only want to create rules which prohibit or restrict an activity where we consider there is such a serious risk of harm to consumers or the rule of law that such measures are needed. We think as well there will be greater flexibility, and the removal of unnecessary restrictions in how we regulate will improve access to regulated services for public and business users who will, as a result of our changes, have increased access to the high standards of professionalism delivered by solicitors. Our aim is for simplification, not complication, and we will make sure that our changes reduce and not increase the compliance burden. We can do this by ensuring that we clarify what our regulations and rules apply to individuals and those that apply to entities. So as I mentioned previously, this separation will enable individuals to focus on the regulation that enables them to deliver ethical and competent legal services, and for entities we regulate, it will be absolutely clear on what rules and regulations apply to them in terms of systems and controls in the way that they deliver their legal services. We recognise this way of thinking and a handbook review and some of the concepts that we've talked about in our working model represent a significant change for the profession. We want to support the profession in adopting these changes. But more importantly, we want to understand what the profession thinks of these changes, what issues our thinking might well present, and how best we can take this work forward. We will undertake a comprehensive programme of stakeholder engagement to listen to the views, ideas and concerns of solicitors and other interested parties. We will also put in place a range of activities to support the implementation of any changes we make further down the line. We will also produce guides and a range of supporting materials for the public as well as the profession. So, moving on to slide 12, our fourth question to you this afternoon. If our rules enabled you to practice as a solicitor delivering non-reserved legal services to the public through a non-authorised entity, would you consider doing this? And again, you should have a yes, no, and an I don't know option in front of you. The purpose of asking this particular question is really just to get a flavour and a snapshot of whether people would take advantage of the law changes that we are proposing under our model. So if you can just take 5 seconds to select a response that is appropriate for you, that would be really helpful. Okay, moving on to slide 13. So I've talked a little bit about what our model might well look like and some of our thinking that sits behind that particular model. I just want to spend a couple of moments now just to outline our next steps. I think it's really important to recognise this is evolution and not revolution. This is not a big bang. This is a phased approach. Our current thinking is that we propose that the review will proceed in 2 phases. And the first phase will be around the practice framework rules, code of conduct and the principles. And the second phase will look more broadly at our wider regulations in terms of how solicitors practice and their behaviours. This first phase, we will consult on principles in spring 2016. We are keen, as part of this consultation, to explore whether we have the right number of principles, whether the current principles remain fit for purpose, or whether they need to be revised, or whether any of the current content can or should be better reflected in our code of conduct. On the other hand, there's an argument to suggest that the current principles may now be so well embedded and understood by the profession that any change may well be disruptive than beneficial. And we want to hear your thoughts on those issues. The second phase, which is in the early stages of development, will be a further piece of work to consider the remaining content of the handbook. This, for example, will include the discipline and cost recovery rules. These rules include a number of procedures and requirements that we think are really inward-facing. They govern our own processes and different circumstances. We want to consider how best we can present this information so it can be readily accessed and understood by the individuals and firms when they engage with those procedures. In terms of implementation of any changes that might arise from those 2 consultations, our current thinking is that it will be spring 2017 at the earliest before any of these changes come into force. So moving on to slide 14. The position paper is really just the start of our conversation with you. We want to engage with you, we want to listen to you, we want to hear your thoughts, and we want to hear how you think we can improve our regulation. We will put in place a comprehensive programme of engagement and communication that will enable you or the organisation you work for to let us know what you think. We will have a dedicated area of the SRA website, and that will provide you with opportunities to tell us what you're thinking. There is an opportunity to join our virtual reference group where you can comment on what we're thinking. There is also an opportunity to participate in engagement events, and we'll have webinars, and we'll have blogs where you can keep up to date with what we're thinking. We want to hear your views. The position paper is just a start. So at a really high level, you can let us know what you think you'd like to see change in terms of our content. You can let us know what you'd like to see us keep. And also, as I mentioned at the beginning, we'd like to understand how you use the handbook, what's wrong with it, what's wrong with the structure, how could we improve its accessibility, and how we can make it a much better product going forward. So in terms of moving on to slide 15, we'd like to just take a couple of minutes now just to collect and collate some of the questions that you've put to us this afternoon. So we'll be back with you in about 2 minutes. Thank you.
Okay, thank you for all your questions, everybody. So we've got a question here which says, why is the SRA looking at the handbook again so soon after 2011, asking if we got it wrong in 2011? I touched on this slightly, I think, already in my discussion. We don't think we got it wrong in 2011. In fact, as I've already said, I think in 2011, the revised handbook that we produced then was a major step change in terms of our approach to regulation. But I think what we realise now is that the market has moved on substantially since 2011, and also we've learned a lot since we introduced the new handbook in 2011, and we want to make sure that we reflect in the new handbook that learning since 2011, and also that we make sure that any new handbook reflects the market as it is now rather than the market as it was in 2011.
A number of you have asked or questioning our ability to simplify regulations. It's a fair question. Since 2013, we've removed 40 rules. We've shortened our handbook from over 600 pages to around 450. And again, there'll be more rules to come out as we move forward. We've also made rule changes for sole practitioners authorisation and PCRE to come in line with other firms. So this is part of our ongoing commitment to streamlining and simplifying the way we regulate.
Okay, someone else has also asked us, how many more times are you going to change the SRA handbook? Well, let's be honest, we are always going to have to keep the handbook under review. There will always be some things that have to change, but what we do hope in the future is that if we can simplify our handbook, make it less prescriptive, make it more outcomes focused, we hope that in the future it won't be necessary for us to change it as often as we have been changing it since 2011, and that's a core objective for us.
A number of you have asked similar questions around what will the handbook look like at the end of this process. It's very, we've outlined in our position paper release today our initial thinking that there will be an individual code and entity rules. And as we move forward in terms of phase 2, we'll be looking at our wider regulations in terms of authorisation and supervision. But what's really driving this is the need to simplify, clarify and make our regulation easier and more accessible to those that we regulate. That's again from a content side. In terms of what the handbook might look like in terms of a physical product, we're really open to hear your suggestions and your views on what it should be. We want to make sure that our rules are accessible, that you understand them, you know how to apply them, and our initial thinking is that we need perhaps a slightly more sophisticated online version with guides and toolkits, but again, we really want to hear what you think.
Okay, someone else has also asked us what will we do to help SRA firms comply with the requirements in the handbook? As Richard's already said, what we're aiming for in the future is simplification, not complication. So we want to take out any unnecessary guidance from the handbook. So in the future, it's very unlikely that the Code of Conduct, for example, itself will have any guidance within it. Instead, we would want to make sure that the outcomes themselves are as clear as they need to be. But what we would like to do is to explore the possibility of providing guidance to those who want it and those who need it through a range of toolkits, online toolkits, which would be interactive, would include videos and webinars and templates and forms, anything that you might need to help you comply with the Code of Conduct. But we would hope that the Code of Conduct itself will be kept very simple, very straightforward and very easy to use. Obviously, we're at the very start of this process. We're still thinking about all of those options at the moment, and we would love to hear from you about what you would find useful, what would be most helpful for you in terms of helping you to comply with any new requirements which come into effect.
There's been a couple of questions around the fact that when we change our handbook and the regulation within it, this has a financial impact on those that we regulate. We are commissioning a piece of market analysis and an economic impact assessment to look at the potential implications of what we are proposing. The flip side, I suppose, of that question is actually if we achieve what we set out to do and create a handbook that is flexible, proportionate, targeted and flexible, the need for constant changing to reflect what's happening in the legal services market will go away, and therefore moving forward firms and individuals be able to focus on delivering legal services rather than constantly complying with updated regulations. So we do think there's quite a potential positive impact in terms of the financial costs associated with meeting our regulation as we move forward.
And someone's also asked us when the changes will be introduced. Richard's touched on this. I think the answer at the moment is that it won't be before spring 2017, but we are keeping an open mind at this stage about exactly when the changes will come in, because as we've already said, we're at the start of the process. We want to talk to as many people as possible about any potential changes. And at this stage, we still don't know the scope of all of the changes. But certainly, we will be giving plenty of notice of any changes coming into effect. We will provide support and guidance, as we've already indicated. But certainly, no changes will come into effect before spring 2017.
Okay, we've sort of covered the main themes as part of your questions. As Maxine said at the very beginning of the webinar, we will take all of the questions away and we will respond to them in terms of the key themes. That information will be available on our website. I believe there will also be an exit survey for you to fill out at the end of this webinar, and we would encourage you to complete that and provide any ideas in terms of any future issues that you would like to see covered by the SRA in terms of webinars. Please read the position statement. Please get involved. There's lots of opportunities to do so. We really do want to hear what you're thinking. And thank you very much for taking the time to listen to us this afternoon.